Alright guys, let's do the revision of the meeting of the board and its power. So let's start this. I won't be able to see your chats as I am teaching in full screen mode. I cannot see them. And if any lag occurs while moving forward in the video, then please manage it guys. But guys, we will start the revision. Okay? This is recording, and if you need it later, I will upload a separate recording for you if the video is live. Okay? Hence, let's begin without any delay. Okay? Without any delay, we will start our revision. What chapter are we going to revise today? We are going to revise meeting of board and its powers. Okay? Meeting of board and its powers. This chapter starts from section number 173 and it ends at 195. From section 173 and ends at 195. Meeting of board and its powers. I will teach you from my notes. Listen to me. We will read it by writing. These things should be remembered by you. Listen carefully to what I'm saying. Okay guys? Listen carefully to me. First, what does section 173 say? Section 173, it's about boards meetings. What does subsection 1 say? If you want plain reading from the books, there's a separate revision video that I uploaded in previous attempt. Watch it. And last time I made you revise chapter 1. You enjoyed it, so I'll be revising from the notes. Entire content will match notes. Listen, what does subsection 1 say? Subsection 1 says that if you want and if a company is incorporated, firstly, within the 30 days of incorporation, first board meeting should be done. There should be 4 meetings every year. There should be 4 board meetings every year. The law states year. What does year mean? It means calendar year. Who told you? Secretarial standard has told us. They will conduct 4 board meetings. But there is maximum 120 days gap between 2 meetings. Gap can't be over 120 days. After that, what did they say? Section 8 companies had different rules. Create exception for Section 8. And for Section 8 companies, every 6 calendar months, they will have to hold board meeting. Don't look at anything else. Every 6 months, what they should do in 6 calendar months, they have to do board meetings. This is your basic board meeting, Section 1. And after that, you come to some exceptions, Section 5, in which they mentioned 4 companies. 1-person company with more than 1 directors. Small company. Dormant company. This is private company that has registered itself as startup. OPC small company. Dormant company or private company that has registered itself as startup and which complies with Section 92 and 137. Okay? What to say about these 4 companies? See, you won't be able to have 4 board meetings per year. So you do one thing. Each half of the calendar year, what do? Do 1 board meeting in each half, 1 board meeting. Keep in mind, what is the minimum gap between 2 board meetings? 90 days, minimum 90 days gap should be there. Maximum you have to see. But the minimum gap should be 90 days. And each half of the calendar year, what needs to be done? Board meeting. This is section 173, subsection 5. I will check notes so that I don't miss any points. I will keep telling you now. After that, if it's 1% company, if it's 1% company, if it's 1% company, what's this? 1% company whose director is less than 1. If there is 1 director, this provision won't be applicable. Is it mandatory for a director to attend meeting? Yes, every director has to attend the board meeting. It's not mandatory for directors to attend. But if you don't attend for 12 months, your office will be vacated by 167. We said, look, go ahead, do it, as anyway, you were made director of the board. Next, there was relaxation for COVID in a period. The gap which was 120 days, they increased it to 180 days. Okay? This isn't relevant. If you see 1 or 2 questions in your question bank where the 180 days concept is applied, after second point is most important, please listen. What does subsection 2 say? That the board meetings can be attended in 3 ways. Can attend in person, do it through video conferencing, can do it through audio-visual means. This video conferencing and audio-visual means, or any means that makes your participation possible. It can record the participations. And the second thing that can record your proceedings. It means that it can record the participants and also identify them. And the proceedings, they can be recorded and saved as well. If it is capable of doing these 2 things, call it audio-visual means. Are you able to identify who all attended the meeting? You are able to record and store proceedings. It's valid audio-visual means. Listen to me. This person said that the company has to make the necessary arrangements. What has to be made? Arrangements. That 1 director is there. Can they attend the meeting through video conferencing? Who will do it? Company will do it. Who will do it? Company will do arrangements. After that, he said that the company's chairperson and company secretaries and their responsibilities come. What are the responsibilities? IFRS, DHS, okay. Now, what is IFRS, DHS? And what does IFRS mean? You will have to take reasonable care of what? Meeting integrity shouldn't be compromised. For integrity, create security and identification procedure. Second, what else you need to see? Providing all facilities, IF. What kind of facilities are these? So that there's proper communication and effective participation. This is IFR. You have to record the proceedings because you will make the minutes by recording it. You will have to store it. Till when to store? Until your audit for that year is completed, okay? Until audit for that year is completed. IFRS is done. DHS director for D. Moreover, besides the concerned director, no one else is attending the meeting. If the person is a differently abled person, then they can ask for help. And HS means you are looking at each other and also listening to each other. Who will ensure this thing? Your chairperson and company secretary. Chairperson and company secretary will ensure this thing and move forward. Next, what happened? Your IFRS DHCS are done. Further, in the notice of the meeting, you will have to tell that our company provides audio conferencing and audio visual. Company gives support through video conferencing. We are talking about the roll call. What is it? Like we used to play in place thing animal. When you come to the meeting, the chairperson will ask you to take the roll call. Hence, each individual has to stand up and speak. Each person will have to tell their name. They have to tell place, meaning which location they are attending from. That means did they get all the agenda and other items, they have to inform. And next is animal. What does animal mean here? It means that is there anyone else in the room besides you? You'll have to tell. After the roll call, the quorum for the meeting will be checked. Chairperson will see whether quorum for meeting is done. What else? If chairperson feels no, the quorum is not completed, then if quorum is done, then very good. Chairperson will declare that the quorum is met. At same time, he will also tell names of people, those not attending the meeting, and you will have to tell their names as well. After that, if director is on video conferencing, we will count them in the quorum. We will count them. Nowadays, it's all about VC. What will be the venue of the meeting? All these things are very important. Questions are asked about this. What will be venue of meeting? Whatever venue you write in your notice, that will be considered the venue. We are talking about statutory registers. Listen to me. Guys, the sign of the statutory register. How is the statutory register to be signed? If the director gave his consent during the call and that consent was recorded, we will assume that they have given their approval and your statutory register has been signed and the dean will also complete it. If the director wants to say anything, first identify yourself. If there is any objection, then what does it mean? If there is objection to business resolution, what will chairperson do? He will call out each member and ask to vote. He will call out each name and ask to vote. When resolution is passed, then he will announce summary of the decision. Then he will also mention names of dissenting shareholder directors. And you have to tell summary of decision and names of dissenting directors. Most important minutes of the meeting. Therefore, guys, please pay attention when I teach. I will answer all queries and don't worry. Okay? Listen to me. Minutes of the meetings. What did I say about minutes of the meetings? Meeting is over. You will make draft minutes. Within how many days will you prepare draft minutes? 15 days. After that, you have to send it to all the members, all the directors. It's not just 2 directors present. Send it to all the directors. They have to give 7 days time. 7 days or as the board orders. Within 7 days, what should be conveyed to them? And if they have any points regarding accuracy of minutes, that you did this wrong, okay? You have to inform within 7 days and what happens then. Furthermore, after that, minutes book will be signed and will go to minutes book. Is this clear? How many days did you get? 7 days. Who will inform after 7 days? Only those directors in the meeting. Draft minutes will go to all directors. But in that, tell me, who will give sacrifice? Listen to me. Let me explain you this in more easy way. Pay attention here. Listen to me. Who will give this knowledge? Directors who attended the meeting will give this knowledge. No other directors can give it. Do you understand? What did I say? Those people are stuck. Make sure to like it so that my motivation stays strong. Moving forward, listen carefully to me. What did I say? Then section 173 subsection 3. Section 173 subsection 3 says notice of board meeting. Okay? Notice of board meeting. What about notice of the board meeting? You will have to send a notice. Who will you send the notice? Listen to me. Notice will go to all the directors. To whom? To all the directors. At least 7 days before meeting. It will be in writing. Will go to all directors just 7 days before. Where will you send it? To their registered address. Whether it be in India or outside of India. Then how will you send the notice? Hand deliver it. Or send it by post. Or send it electronically. Can I send notice for shorter period? You can send it, but 2 conditions should be fulfilled. If you are conducting urgent business transaction and at least 1 independent director attends meeting. But if even 1 independent director doesn't attend, then it's fine. The minutes of your meeting. Circulate it to all directors. and at least get it ratified from one independent director, get it approved, your work is done. If a company does not have any independent directors, then you can call them for urgent business. Your shorter period notice will be considered valid. Is urgent business in Companies Act? No, it's obviously depends on case to case basis depending on the practical scenarios. What did I say then? When you send the notice for the meeting, you will have to write in the notice. Besides that, our company gives you the facility to participate through audio-visual means as well. If you want to participate, you will have to communicate your intention. Prior intimation means to inform beforehand so that we can arrange for you. They have given another option at the start of the calendar year. You can also mention that what will you do in the whole calendar year. Attend through video conferencing. And by this way, you can also give intimation. Intimation is valid for 1 year. But after giving that intimation, if you want to change your mind, will I be able to attend physical meeting? So you can go and sit, but you need to intimate sufficiently in advance. Okay. So that your seat can be arranged. Basically, we will explain to you that you can join through video conferencing. Give intimation. If you want, give intimation for entire year at start of year. And even after giving intimation. If you think that I will attend this particular meeting physically, then that you can also do by writing. You can tell by giving prior intimation. What did I say? Section 173, subsection 4. Okay, guys. Let's begin again. There was little internet issue. I'm listening to you. Okay. What did I say? We read about the notice that if there is a failure in sending the notice, if there is failure in sending notice, how much penalty will you have to pay? 25,000. Speak along with me in the comment box. How much penalty will you have to pay? 25,000 rupees. After that, who will send the notice? Tell me, who will send the notice? This notice will be sent to you by the board of directors, the company secretary, or any person who is authorized by board. Can we send the notice through email? We can send it, hand delivery, courier, or electronically from board. Is it necessary to send the meeting agenda? It's not necessary to send the meeting agenda. Law says it is not necessary. But as a good psychological practice, you can send it, but we know that eventually point will come when sending the agenda becomes necessary. Okay. If you haven't sent notice to any member, Parmeshwari Prasad Gupta versus Union of India. You haven't sent notice to any member. If you haven't sent notice to any member, they said it's fine. So the meeting that you have, it will be void and the resolution will be invalid unless ratified by the director. Then after that, notice of adjourned meeting. Notice of adjourned meeting. The notice of adjourned meeting. Notice of adjourned meeting. What is that? If your meeting is adjourned, is it necessary to send notice? The adjourned meeting is nothing but nearly continuation of original meeting. Original meeting is continuing. There's no need to send notice, but there are two exceptions. Meeting that has been adjourned and it's signed I adjourned. And is it written in this AOA that you will send notice for adjourned meeting? No, it is not written in the AOA. So you will have to send it, but otherwise you won't have to send it. In which two cases you will send? If it's written in AOA. And the second meeting is signed I, meaning adjourned for an indefinite period. Okay? Moreover, what if the director in front says that I don't need the notice, you don't need to send it? So will you avoid sending it? No, the person in front is waiving off their rights. This doesn't mean you can waive off your duties. You still have to send the notice. In the case of alternate directors, will the notice be given to both of them? Yes, notice will be given. Original, alternate, additional director. Interested independent director, everyone will get the notice. Will notice be sent outside India? Yes, if any director's address is outside India, then it will go abroad. Furthermore, can you just attend the meeting in audio mode? Can you attend meeting in audio mode? Is it possible? No, you don't need video for the meeting. Audio visual, both are required. Okay? You can't just have meeting through audio. Don't think about having meeting over conference call. After that, what did I say? After that, I said section 174. Listen carefully. Section 174 first, we need to understand what quorum is. In case of company, what will be quorum? Tell me, what is the quorum? Quorum is 1/3 of total number of members. Or 2 members, whichever is. Higher, whichever is higher. 1/3 of the total number of members or 2. But in the case of section 8 company, the said quorum is 25% of members. Or 8 members, whichever is lower. Section 8 company has exception. They said 25% of the members or 8 members, whichever is lower. I will tell you one thing in quorum. Should quorum be at the start of meeting or should it be throughout? Quorum should be throughout the meeting. The 1/3 of total number of members here. In this total number, will you exclude anyone? No, don't exclude anyone. And if a director's office is vacant, if it's vacated, don't include it in total number of directors. What did I say? At the beginning of the board meeting, it's checked throughout the meeting and after that. Two cases are different. If director is continuous, meaning directors left in the company. If the minimum quorum requirement is less. Remaining directors. What can those remaining directors do? Law has given them two powers. If one director remains, so the law gave him two powers. He can either appoint a new director. Director appointed another director. As much as is required for minimum quorum. For quorum, appoint as many as required. Or you can give power to director alone. Okay? Call general meetings, call shareholders general meeting. If it happens that the continuing director, the number of continuing director is lower than the required quorum, then continuing director will have two powers. And secondly, if in your company the interested directors are more than 2/3 of the total number of directors, interested directors are more, what will the quorum be? Quorum will be number of interested directors who are present in the meeting, and two directors, whichever is higher. Number of interested directors present in meeting, or two directors, whichever is higher. So that will be considered your quorum, and we won't fuss about it anymore. There are two special cases. If limit of continuing directors are lower, and if there are more than two interested directors, then what did I say? In case of private company, tell me one thing. If there are interested directors who attend meeting, are they counted in quorum? Okay, guys. And number of non-interested directors, it will be non-interested directors. Can you tell me if interested directors are counted for quorum? No, interested directors disclose their interest. They don't participate and they are not counted in quorum. But in the case of a private company, interested directors disclose their interest. They also participate and are counted for quorum. They are also counted for quorum. Private companies are exception. If quorum is not reached in meeting, then what if quorum is not reached in meeting? Then meeting will be adjourned to next week. Same day, same time, same place. Next week, same day, time and place. If the next week is a national holiday, next succeeding day, which is not national holiday, you will have to hold meeting on that day. Is Sunday a national holiday? Absolutely not. It's not appropriate to tell such things. After that, I said if director is participating from VC or AV mode, whether we will count him in quorum? Yes, we will. Now, very important point. The article of association that you have, it can highlight a higher number of quorum, meaning that the quorum can be higher than a limit. Do you understand? The quorum can be higher than a limit, okay? Did you understand or did you not understand? I hope this is clear. Yes, let's move on. What did I say to you? I said provision for the quorum of interested directors is basically over. Furthermore, can you tell me something? Can the board of directors hold a meeting on a national holiday? Answer is yes. Adjourned meeting can't be held on national holiday, but ordinary meeting can happen on a national holiday. Then will alternate directors be counted in the quorum? There is an important question. Listen to me. If a meeting happened, if original director joined by video conferencing and alternate director is present physically, if original director is present in meeting, no need for alternate director. Original director will be counted for quorum and his vote will be counted. But let's say if the original director has left in the middle of the meeting, instead of him, count alternate director in quorum. This is question number 13. You all should solve it. And what's maximum number of directors present in quorum for AOA? Can you write in the AOA that our company has a total of 15 directors, but only maximum of 12 people can attend the meeting? No, sir. There is no maximum quorum. The quorum is always the minimum. Quorum is always minimum. After that, section 175, resolution by circulation. All right, we'll do it quickly. Listen to me, see this. Listen to me now. Resolution by circulation. Who do you send this circulation? You draft a resolution and send that draft resolution to all the directors. Where will you send it to all the directors? You will send it to their address which is registered in India. It won't go outside India, the circulation. It will go to all the directors. Then how will you send it? Can you also hand deliver to them? You can also send through post or courier or buy electronically. And when resolution will go, if majority of the directors who are entitled to vote, meaning those who have the right, the one with the proper rights, and if they are voting, then will it not be considered? Or will it be considered that the resolution has been passed? Can interested directors vote? No, only entitled directors can vote. Clear? Now you have sent the resolution in draft. And next, against the draft resolution, there may be resistance. What does it mean? If 1/3 or more directors reach to the chairperson, if 1/3 or more directors went to the chairperson, this is in resolution by circulation. How are you doing this? It should be in board meeting. The chairperson will be bound to do what? To put that resolution in board meeting. But this request that you are making should be done before resolution is passed. Don't do it afterward. And if this resolution that is being circulated is passed, then you have to add this in the minutes of your upcoming board meeting because this happened separately. Is this clear? It didn't go to any minutes. In next board meeting, you need to tell them that we passed resolution by circulation and include it in the minutes. I will tell you something. You know, this resolution by circulation, this is just resolution by circulation, right? And this is not for board meeting. It's applicable for audit NRC stakeholder relationship committee. Anyone can use it. After that, there are some sections, right, where resolution by circulation is not allowed. I told this earlier. Now listen, how will you understand? Sections where resolution by circulation isn't allowed. You have to pass resolution in the board meeting, okay? So first of all, you are filling the vacancy casually in 1614. In 179, we studied about the powers of the board. Political contribution and loan guarantee security is done. Related party transaction is done. This all you have to do in board meeting. Resolution by circulation isn't allowed. 176. Defect in appointment not to invalidate proceedings. What does that mean? See this. What happened if you appointed another director and it was discovered after appointment, like 1 or 2 years, that appointment was defective. Okay? It was unintentional but defective. So this point came when it was appointed until it was found defective. In that phase, whatever work he did will be considered valid, not invalid. Okay? And when it was discovered that the appointment was defective, any work done after that point will be considered invalid. Clear? When he didn't know, until then, all the work will be considered valid. While work will be considered invalid after that, that's all the provision. There is nothing more. We're talking about the audit committee. The audit committee, see this? And one note to revise, listen, section 177 says about the audit committee. First provision of the audit committee, who is it applicable to? And provision under section 149 subsection 4, is it applicable or not? Audit committee applies. What does that mean? Listed, unlisted, public company, whose paid up share capital is 10 crore or more, right? Moreover, if turnover is 100 crore or more, or the outstanding loans venture borrowings which are over 50 crores, that will be applicable to it, or this will be applicable to them. Is this clear? It won't be applicable to 3 companies: joint venture, completely owned subsidiary. Joint venture, completely owned subsidiary or dormant company, then if for 3 consecutive years you are not meeting conditions. Therefore, this provision for audit company won't be applicable to you. Okay? It's the same thing we did in 1494. What will be the composition of the audit committee? Who all will be in the audit committee? Listen, law says you need at least 3 directors. Out of that, we need majority independent. How many? Majority independent. Okay? Majority means if your company has 6 directors, if your audit committee has 6 directors, you need 4 independent directors. 4 independent directors. After that, they said majority, including the chairperson, should have ability to read and understand financial statements. They should be able to read and understand financial statements. Then what does the audit committee does? And it will do the work that board of directors told it through terms of reference. Is this clear? Through the terms of reference. It's been told through terms of reference. What work has been assigned through the terms of reference? For terms of reference, the first thing you need to remember is the shortcut, which is a safe RPT. First thing is all the points related to auditor. What are those points? The auditor's appointment has been done. Here, the auditor's remuneration has been done. And do you know who will tell you all the terms of his appointment? Audit committee will do that. Once the appointment has been made, who is going to check whether audit is being carried out effectively or not, and whether it remains independent or not? Who will check these 2 things? The audit committee. And when the report on the financial statements is given, who will examine it? Audit committee will examine it. I had explained that appointing auditor, making sure his job is done and finished. These 3 are responsibilities of audit committee. Let's talk about safe now. What do you mean by safe? If you want to do scrutiny of any intercorporate loans or investment, what does A mean? You should be ahead of me. S for scrutiny. A is assets valuation, if you are getting valuation done. F stands for internal financial control or risk management systems, evaluation. And E, end use of funds. If you have withdrawn money, who monitors its end use? The audit committee. I'll repeat, scrutiny of intercorporate loan or investments. A is assets, meaning valuation of assets or investment. Then what was F? It stands for evaluation of internal financial statements or risk management. And last was E. Now what was the meaning of E? So E stands for end use of public money. And who is going to monitor the end use of that money you have taken from the public? The audit committee will monitor it. After that, we read about related party transaction, that the audit committee will approve all related party transactions. And what's more, if it likes it, then it will also give the omnibus approval. I'll repeat, it will give omnibus approval. But listen carefully. Here, if audit committee doesn't approve any related party transaction, and that related party transaction isn't of 188, then it recommends it to the board and mentions that it isn't approving it end. And it's up to board if they want to approve it or not. Let's say a company has entered into a related party transaction, and if it is without the audit committee's approval, the law says to get it ratified within 3 months. If it's not ratified within 3 months, what option does the audit committee have in that case? It will be voidable. It shall be voidable at option of audit committee. And in fact, the director who authorized this, or the director because of whom it is related party, He will also have to indemnify the company, meaning he will have to compensate for the loss. And this entire provision will not be applicable if there is any transaction between holding company and wholly owned subsidiary. If related party transaction happens between holding company and wholly owned subsidiary, then the approval will not be needed. But what does omnibus approval mean? So what does the omnibus approval mean? The board creates a criteria and gives it to the audit committee. On the basis of that, the audit committee gives omnibus approval, meaning a blanket approval. So do related party transactions repeatedly. What will this criteria be? You will have to explain a lot of things in the criteria, like for which related party transaction can you give omnibus approval? What disclosure must you provide when you are seeking omnibus approval? What kind of review will be done? In which periods will we review? And what are the transactions that are prohibited where you cannot give omnibus approval? What is happening here? The board is basically setting up a system here. And when you go to the audit committee, it will look at two things. First thing is repetitiveness. Second is justification. Repetitiveness, number of repeated transactions. And justification means, is it justified to give an omnibus approval in this particular case? Once both things are checked, then the audit committee passes a resolution. And through resolution gives omnibus approval. When you are giving the approval, then you need to mention everything. First of all, you need to mention the maximum amount of the transaction. What is the maximum amount per transaction? After that, you will have to tell which transactions approval was received with which related party. And you will also have to tell many other small details needing explanation. Then I explained that if you are not getting any justification, if you don't understand the reason for giving the omnibus approval, can you give approval in that case? Law says you can. But the transaction should not exceed 1 crore, which is the limit per transaction. Limit per transaction is 1 crore and shouldn't exceed that, and omnibus approval can be granted. But what is the validity of the omnibus approval? 1 financial year. Whenever you take approval, it is valid for 1 financial year. Lastly, there are things for which omnibus approval can't be granted. Let's see those. If there is any sale or purchase of undertaking, omnibus approval can't be given for that. I will repeat this point. If you have to sell or purchase an undertaking, you can't give the omnibus approval for that. This was the entire omnibus approvals point. I hope you understood it. Let me just check for any missing point. Did I mention that ratification will only happen if the amount is less than 1 crore rupees? I will repeat, ratification will only happen if the amount is less than 1 crore. If it exceeds 1 crore, law does not provide any option for ratification. After that, all of you will need to take a look at all these things. That's it. Nothing else is missing. Remember 3 things about rights of audit committee. It can ask for comments, review the financial statements and discuss it. CRD, the audit committee can request comments, review and discuss them. After that, if some kind of investigation is required, you can investigate as well. And you can get professional assistance for that and hire people from outside. Will the auditors of your company and key managerial person have the right to attend audit committee's meeting? Yes, they shall have the right to be heard in the audit committee's meeting, but they shall not have the right to vote. They will have chance to be heard, but not the chance to vote. And lastly, the responsibility has been placed on the board. What is that responsibility? Listen carefully, the board will be responsible for disclosing. What is the composition of the audit committee? What else is there? That the board has not accepted any recommendation of the audit committee. What has the board not done? Not accepted any recommendation of audit committee. It has to disclose this if this happens. Disclose the composition and state that it did not accept recommendation. Next is a very important concept. Look here, what is vigil mechanism and which companies is it applicable on? You have to apply it to listed companies. Besides that, it's applied to every company that's taken deposits from the public. From whom did they take deposits? The public. And the third one is the company whose borrowing is more than 50 crore rupees. If company meets any of these 3 conditions, what would you apply to it? The vigil mechanisms provision. What happens in vigil mechanism? You have to put in place a system where people can report their genuine concerns. So you have to put in place a system where their genuine concerns can be reported. Next question, who will oversee this mechanism? If company has an audit committee, then audit committee will do it. If there is no audit committee, then you will authorize a person or you will assign this task to the one who will oversee this process. The biggest advantage of the vigil mechanism is as follows. You should make sure that there is necessary safeguard against the victimization. What does safeguard against victimization mean? The person who goes and complains should not suffer any personal loss as a result, and you should ensure this happens. And besides that, if it's a very serious concern, you will also give that person access to the audit committee's chairperson, so that this individual can directly go to the chairperson of the audit committee as well. This is the entire provision. Next, I said, if someone's making repeated frivolous complaints, means he is making false complaints repeatedly, action can be taken against him, including reprimand, calling him for questioning. These kind of things can be done. Now listen, whatever vigil mechanism you have created and whatever process is created, it should be put on your website and also included in the board's report. These things are done. And last, if there's contravention of section 177, there's a penalty in that case. 1 lakh rupees has to be paid by officer in default and 5 lakhs by the company. It's a fixed and a very important penalty. The OID must pay 1 lakh rupees and the company must pay 5 lakh rupees. Tell me something. Your paid up share capital should be 10 crores or more, turnover 100 crores or more, or loan 50 crores or more. But let's say that none of these limits are met. Suppose my paid up share capital is 5 crore rupees. Then, is it possible to set up audit committee? Answer is yes. There's no problem if you want to set it up at your own will. Nobody is going to stop you. This was audit committee. Next we have 178 discussing two committees. First, nomination and remuneration committee. Second, stakeholder relationship committee. Nomination and remuneration committee is applicable only to those on whom 149(4) all audit committee is applicable. It's applicable on them only. What's the composition of nomination and remuneration committee? In this too, there are 3 or more than 3 non-executive directors. And from this, at least half, I'll repeat, at least half of them are independent. And at least half means that if there are 6 non-executive directors, then 3 independent directors will suffice here. But if there are 6 directors in audit committee, at least 4 independent directors are needed, because the word used there was majority. What did we discuss after that? What was stated about the person who is the chairperson of the company? He can't become the chairperson of nomination and remuneration committee. Whether he is an executive or a non-executive, it does not matter to us. But he can become a member of nomination and remuneration committee. I explained this earlier. The chairperson of the company, take Mukesh Ambani of Reliance, he cannot become the head or chairperson of nomination and remuneration committee, but become a member. He's executive director, how will he become a member? It doesn't matter. We have just one exception. The non-executive director of the company or chairperson can definitely become a member of the nomination and remuneration committee if he wants to. What does it mean? Can Mukesh Ambani of the Reliance company become head of NRC? No. Can he become a member of the NRC? Yes. You can't say since he's executive director, he can't be member. You have to live in India after all. This was composition of NRC. What is the function of NRC? What was the first thing? Can you all just confirm in the chat whether you're here? It's no fun otherwise. Please like the video if you're watching on YouTube. Are the concepts clear? If you want to motivate me, please like the video. Are you even present here? I need to know. At least interact a bit with me. Okay. Let's proceed. What is the function of the nomination and remuneration committee? What is its function? Firstly, it has to hire. What does hiring mean here? To find people who can become directors in the board of directors, or hired in senior management. Senior management is one level below the board of directors. Or consider the department heads. They are also part of the senior management. Who hires these people? The nomination and remuneration committee. Now, after the nomination and remuneration committee does the hiring, you will decide their remuneration and decide the methods by which you can perform their performance review. In fact, reviewing independence of independent directors is responsibility of nomination and remuneration committee. Lastly, if you don't like them after performance review, then you can also remove them. Doesn't it feel the same as the job of HR? Whose job is it? The nomination and remuneration committees. Who forms stakeholder relationship committee? It's for company on which 149(4) is applicable. That's false. Stakeholder relationship committee is formed by every company with more than 1000 stakeholders. Like there are debenture shareholders, equity shareholders. If combining all 4 at any time of the year, meaning if debenture, equity and preference holders when combined cross 1000 at any time of year, SRC provision applies to that company. If the SRC provision is applicable, what will be the composition? There's not much needed in this case. Just the chairperson of the SRC is needed to be one of the non-executive director. Rest is decided by the board. The head has to be kept as non-executive director. The board will decide rest. What will be their function? Their function will be to address the grievances of the investors. If any investor has complained, they have to address it. I showed you Reliance's grievance redressal in class. Now, listen. Grievances have to be addressed. Listen to me carefully. But if you have tried to address the grievance in good faith, you tried to address it in good faith, but it couldn't be addressed, there won't be any contravention. There will be no contravention and no punishment for you. But if contravention of this section happens otherwise, what penalty will be imposed on you? There will be penalty of 5 lakhs on company and 1 lakh on officer in default. I'll tell you some common points. These two committees, NRC and Stakeholder Relationship Committee, and in fact Audit Committee too, their chairperson will be required to attend the annual general meeting, and he will need to answer as well. And if the chairperson is not available, then some person authorized on behalf of the chairperson will have to attend. So that person has to attend the meeting and answer the shareholders. He will have to answer the shareholders. Clear? This was about 178. Next, 179 is very easy. 179 discusses the power of board of directors. The board can do anything that the company can do, but condition is it has to be done within the purview of the MOA and AOA and not do anything that the shareholders have been asked to do. Can anything restrict power of board of directors? Yes, shareholders can restrict power of board of directors, but that restriction will be applied prospectively, meaning it will apply to future things and not apply to the current ones. Board resolutions or board decisions are made in two ways, in board meetings and resolution by circulation. But there are some things for which you are not allowed to do a resolution by circulation. You will need a board meeting. I divided it into 5 parts to help you remember: cash inflow, cash outflow, financial statement, badi baatein, or BBB and others. What comes under cash inflow? Understand cash inflow and outflow. Under cash inflow and outflow, if you have some shares and you call it. If there was unpaid money, it was called. Or you issued new shares, securities or debentures either in India or outside of India. Or if you have done a buyback under section 68, I'll repeat, if you have done a buyback under 68. Up to how much can the board buy back under section number 68? Let me tell you, the board has a limit. The board can only buy back up to 10% of the paid up equity share capital and free reserves. If you do that much buyback, then it will also work, but you'll need a board meeting. In addition to that, what else did I explain? If you are borrowing money or if you are investing money, or if you are giving a loan or a guarantee or security, the law says that for all these things, a resolution needs to be passed in a board meeting. So pay attention. Either there is cash inflow or cash outflow. For the financial statement or the board's report, if you are asking for approval, for the board's report's approval, you have to do it in board meeting. Then for big things, there are 4. If you talk about diversification, this chair's falling down itself. Look here. Okay. If you are talking about diversification, takeover, amalgamation, merger, diversification, takeover, acquisition, amalgamation, merger, diversification, takeover, acquisition, amalgamation, merger, you should discuss these big things in the board meeting. What comes under others? PAK? P if you want to make a political contribution. Next is A if you want to do appointment of auditor. Which auditor? Internal auditor or secretarial auditor. And what is K? If you want to do appointment of the key managerial person. Where will you do all these things? The board meeting is where to do them. But the law has made exceptions for these 3 things. What did the law say? If section 8 company wants, then these 3 things can be done through RBC. Because section 8 company wanted something different for itself. So it's stated that if the company wants to, it can delegate this power by passing a resolution in board meeting. Tell me, which power are we talking about here? Either you will delegate it to any of your committees, like you have a finance committee, or you can delegate it to a manager or managing director, or the principal officer or the principal officer of the branch. You can delegate it to these people. And regarding this provision for the borrowing and investment, this doesn't apply to banking companies. If a banking company takes money from public, or if it is making deposits in another banking company, that is not considered a borrowing investment. And one important point to keep in mind is when we use borrow, what does it mean? When considering ODCC limit for first time, or when that limit's increased, so we call it borrowing. When you get approval for the ODCC limit of 100 crore rupees, out of 100 you took out 1 crore, put in 2 crore and took out 5 crores. Doing this kind of transaction won't be considered as borrowing. When you are getting the primary approval, only then you will need approval for this in the board meeting. Otherwise, you will not need the board's approval. Okay? Are you understanding? We are reading section 179. Next question is, can the shareholders exercise the board's power? No, they can't. Shareholders cannot exercise the board's power at all, but there are 3 exceptional cases. If board of directors action is malified, meaning if works done in a malified manner or incorrect manner. Then second, if all the directors are interested. And third, if there is a deadlock in management. Who will have to interfere in these cases? Shareholders will have to interfere. Section 180 is very important and I am explaining it in the form of summary. What does section 180 state? You have to keep in mind that it is revision. Here, we are revising 10 hours long content in 1 hour. The content will be fully detailed, but there won't be any repetition, so I need your full attention. I mentioned that there are 4 things. Restriction on power of board, meaning a board resolution is required and SR also needs to be passed. What are those 4 things? Focus. The first one is clause A of subsection 1. If you want to sell, lease, or dispose any undertaking, wholly or significantly the whole, if you want to sell, lease, or dispose any undertaking. Here, an undertaking means something where you have invested 20% or more. Investing more than 20% means over 20% of total income comes from that. or over 20% of net worth is invested in it. This is more than 20% of the total income. So this will be an undertaking. Are you selling this undertaking completely or significantly? Significantly means 20%. The law says that you have to pass a special resolution and get approval. But if you are making this sale in the ordinary course of business, this is regular business of building and selling real estate properties, then there is no need to pass any special resolution. Another point, let's say if you sold it without getting SR passed, will the one in front get good title? The law states if he purchased it in good faith and he has done his due diligence, he will get a good title even if he is unaware about that, and his title will not be affected. This was first point. Second point, if you are doing an amalgamation or merger and there is compensation arising from it, and you are talking about investing that compensation, law dictates asking shareholders. But if you are investing the compensation in the trust securities, which trust securities? They are the ones created under the Indian Trust Act. The law states that there is no need for approval. You can go ahead and do it. Those who can interact with me through chats, tell me if there's anyone who dares to watch this video at 1.5x speed. Is anyone watching at 1.5x speed? And the limit is when you watch it at 2x speed. So listen to me. Watch it at 1x cause my pace is 3x. Back to the topic. Second one was about amalgamation and merger. Now what's the third one? It starts with L. What is it? It means if your existing borrowing plus the proposed borrowing is beyond the limit. The limit is paid up share capital plus free reserve plus security premium account. It's beyond this limit, security premium account will be given in question. Listen carefully, what do you mean by free reserve? It means every reserve that is available for dividend distribution. Under paid up share capital, preference and equity get included. Preference and equity both come under it. In existing and proposed borrowing, take entire borrowing of company. But keep in mind that if you have taken any temporary loan from the company's banker, and that too is in the ordinary course of business, then don't include that. What do you mean by temporary loan? The loan that is payable on demand or within 6 months. If you have taken it from company's banker in ordinary course of business, don't include that in the limit above. But in case you took this same money to finance the capex, which stands for capital expenditure, then you will have to include it. What's the only thing not to be included? Any temporary loan you took from your company's banker in ordinary course of business. But if you use that same money to finance capex, then you will have to include it back within this limit. And if the borrowing of this limit is going beyond the limit, then you have to pass the SR in that situation. But I'll tell you something. If you took a loan without passing the SR and if the other party has given it in good faith, then the other party's title won't become defective and it can recover money from you without any possible issues. Did you understand what I explained? Tell me. At last, there's E. It means if you want to give a remittance or an extension to director for the due payment of the debt. Their payment is due, and if you want to give them an extension on that due payment, then you will have to get the SR passed. You will have to get SR passed for these four. Let me check for any missing point. We completed everything, right? Let me tell you, all are done and you don't need to read anything else in this. Now read 3 more sections along with this. Section 181, 182, 183. So can we summarize this on one page? Section 181. If there is a public or private company, if they want to make charitable contribution, it can do so. But if it's 5% off, 5% average net profit of 3 financial years, if it's over 5% net profit of past 3 years, if 5% more from net profit of past 3 years, then you will have to get approval from the OR of the shareholders. Since limit is low, only board resolution is needed. What is limit? 5% of average net profit for past 3 financial years or more. 5% of average net profit for past 3 financial years or more. Hence, this is the limit. Is this clear? Tell me, did you understand or did you not understand? I hope you understood. After that, what did I say? If you are doing charitable contributions, if you are doing this for employees' benefit, it won't be considered charitable. Now, if in the last 3 financial years, and my profit was 10 crores 3 times, what is the average of 10 crore? 10 crores is the average. What is the 5% of that? Hence 5%. That means what? It means that till 50 lakhs, I can invest or do charity. In the current year, I have a loss and I'm saying I will make a charitable contribution of 40 lakhs. I have loss in current year. Can I do charitable contribution? The law said yes, your current year's loss does not matter. You have to see average of last 3 years. And the loss in the current year doesn't make any difference. After that, let's talk about 182 political contributions. Limit in political contributions? Modi ji said there is no limit on political contributions. Just one condition, whatever political contribution you make, it should be approved by board resolution. Or biggest condition is, it has to be done in the board meeting. Resolution by circulation will not work. So that will not work in board meeting. I hope this point is clear to all. Let's move ahead. It can't be by board resolution but in board meeting. Now the two companies are prohibited from political contributions. Government company and another is the company that had 3 financial years. There was detailed discussion on financial year. Remember, company which is in existence for less than 3 financial year. If you haven't completed 3 financial years, then law says you cannot make political contributions. Some things are deemed political contributions. What I mean is, if you're giving money to someone if you have contributed to a person like that, who is doing such things, that affects political party's support, the political party's support will likely be affected. So, law said this money will be political contribution. If you are advertising in the political party's souvenirs, brochures, pamphlets, what are you doing? Advertisement. Law says, do you think as kids? So understand this, we will consider it as deemed advertisement, right? It will be political contribution. And law said if you are making political contribution, you'll have to show the amount in the P&L that we made political contribution. While at the same time, you have to keep in mind the board's political contribution. It will either be through check to account or through bank draft to account. This will be done through electronic clearing system, but don't do it in cash. Account pay check or bank draft or electronic clearing system. And then you won't have to disclose it in P&L. Furthermore, if you are routing through the electoral trust company, what is it? It's the electoral trust company. If you are giving 10 crores to BJP or to Adani, 10 crores to Congress, you have to show both separately. If instead of giving it to both separately, you put it into electronic trust company, then law says no need to show the split. Then you can say in P&L that I have given 20 crore to electoral trust company. I don't need to show how much I gave to the BJP and the Congress. And lastly, if you have mentioned contravention, then you will be penalized. What will be the penalty? You will be penalized with up to 5 times the amount of contribution to company, and officer in default will be imprisoned for up to 6 months. And along with that, you have to give penalty of 5 times. This entire provision is from section 182, which deals with political contributions. Let me tell you about provision for political contributions. It is notwithstanding anything contained in any other provision of act. So what this does is it overrides the entire act. Section 183 is easy. It's about contribution to National Defence Fund. Law says there are no restrictions here. We are saying that notwithstanding this act, notwithstanding MOA, the AOA, the agreement, nothing will be withstanding. First of all, it says that there is a board of directors. Board of director or anyone who exercises the power. Shareholders wants to donate to the National Defence Fund or donate to a similar fund in the general meeting. They want to donate. The law says you can donate, you can contribute. No one will stop you, and at the same time you will disclose the total amount in your P&L. What will you do in P&L account? You will disclose total amount that we contributed to National Defence Fund. Are there any specific mod or conditions? We haven't told you anything. We've only mentioned basics. We just told you that you can contribute. Sections 184, 185 and 186. These are very large provisions. Sections 184, 85, 86. I need your 100% attention here. Listen carefully to me. What does section 184 states? It says that there are 2 types of disclosures. One is general disclosure and a specific disclosure. Listen carefully to me, guys. And it says that every director will file an MBP1 to the company. And in MBP1, they will state their concern or interest. In corporate body, in firms, in association of individuals, he will state his concern or interest. Wherever he gives interest, will inform company. He will inform company or board of directors. When will he inform directors? He will inform directors in his first board meeting. Inform in first board meeting of every financial year. And whenever your concern or interest changes or is affected, right? You have to disclose everything in MBP1. What is this? It's the basic point. We understood that you have to give general disclosure. Let's see special disclosure. What will you do in special disclosure? Now I am going to say about specific disclosure. If this is a company and it's doing any kind of contract or arrangement with someone, in which if your director is interested, then he will disclose his concern. The director will disclose his concern. Clear? And he will not participate in transaction, okay? But what does interested mean? When you say interested, what does interested mean? Tell me. Listen to me, this person could be a body corporate, or it could be some firm or other entity. If it's body corporate and director of your company, with that body corporate, they alone or with other directors holds over 2% of shares. Or if he is a promoter, a CEO or a manager of that body corporate, what is he, guys? Tell me. Or if there is firm or another entity, then that firm or another entity is partner, owner or member. I mean, if there are important people, and this director will be considered interested, and after being interested, he will disclose his interest. Is that clear? And he will not participate in the meeting. If he participate in the meeting, then, and if he participates in the meeting, then that meeting becomes voidable. That becomes voidable. And you will be subject to separate penalty for contravention. You will disclose your interest but won't participate. But if you are a private company, if you are a private company, then you will have to disclose your interest. But along with that, what can you do? You can also participate. What can you do? You can also participate. Will you be counted in the quorum? Yes, you will be counted. Moreover, we have created an exception for Section 8 companies. This is for Section 8 companies, okay? We said this provision that is above, right? This will all apply if a company is doing a transaction with its related party. An amount how much? More than 1 lakh, okay, right? If transaction is more than 1 lakh rupees, this provision will still be applicable if company has government or a Section 8 company. And this last point, it is important. This is also point from the exam. Furthermore, if one company and another company have any contract or arrangement, hence a director of this company will be considered interested in it only if he hold 2% or more of the paid up share capital. Then only it will be considered, otherwise he won't. And if he hold 2% or more of the paid up share capital, then he will be considered interested. What do you mean? Stop. What I said, if the company holds less than 2% of paid up share capital, he won't be considered interested. What does this mean? This means it is very simple. If transaction is happening between two companies, the transaction between two companies, is that right? So don't look at the promoter CEO manager thing. If transaction happening between two companies and if this director holds paid up share capital in the other company, then only it should be considered interested, otherwise no point in it. Understand, this is your Section 184's whole provision. Now 185. We are talking about 185. Listen very carefully to me. Furthermore, we are talking about 185 loan to director. I told you that this you have to remember this in 4 boxes. First of all, we need to remember prohibition. What does the prohibition say? The law states that no company, they can't provide any loan, guarantee or security. To whom? To any of the directors or to directors relative or to his partner, or to their own company's holding company's directors, or to relatives of holding company's director, or to any such firm where your company's director is present. Is this clear? Or to the director of your holding company. Or if their relative is the partner here. If their relative is the partner, you cannot give loan to this firm, and who else you cannot give? To company's directors or their relative or the partner. Think about it. To holding company's director, relative or partner. Or a firm where your company's director, firm where company director. Or their holding company's director or their relatives. If they are a partner, then you cannot give them a loan either. Is this point clear to all? This prohibition has been put in place. Then we said, if there is a company which is giving loan to a private company or a corporate body, then if it's giving loan to a private company or a corporate body and your company's director is interested in it, law says you cannot give it. If you have to give, you will have to get an SR pass. Furthermore, after getting SR pass, you will also have to. This needs to be kept in mind that money for this loan is being used for principal business activity. Besides that, it's not for anything else. After SR pass, you will have to give all the details in it. Give full particulars that why are we giving this loan and how much are we giving. You have to give every detail. But can you tell me what does interested mean? Interested means what? The same as what we read in Section 184? No. They said they would be interested if a private company is being given a loan. And if your company's director is a director or a member of that private company, then it will be considered interested. Or if you are giving a loan to a body corporate, so your company's director, along with other people, holds 25% of the voting power. They hold 25% of the voting power. Or if your director says so, then this body corporate, its board of directors is accustomed to act. Okay. Accustomed to act, what does that mean? It is bound to act because there must be an agreement, right? Law said in that case, it will be considered interested. And if even one director is interested, then this loan will have guarantee or security. Restrictions, meaning you have 2 conditions that apply. Is this clear till here? First one was prohibition, meaning they won't give loans. Second restriction means they will pass SR and give for the principal business activity. I told you, this provision we read above, it has 4 non-applicability points. First, if you are giving loan to your full-time director or managing director, on which capacity? Employees capacity. Either you're giving them according to their agreement of service. So when you hired them, you are giving them according to the service agreement, right? Or maybe you have created some scheme by SR pass under which you are giving loan to MD, WTD. Law says it will work, there is no problem. Next, if there is company whose ordinary course of business is lending, is giving loan in ordinary course of business, and the interest rate in that is higher than the government yield, law said do it, there is no problem. You know, a bank's job is to provide loan, guarantees, security. If their company's own directors come, they won't refuse, they can give it. Next, if a holding company is giving a loan, guarantee or security to its subsidiary, Just tell them to go ahead, no worries. Remember, holding company is using its subsidiary for its principal business activity. While the fourth, if holding company is not providing loan guarantee or security to its subsidiary, if it's providing guarantee or security to its subsidiary company for principal business activity. So this provision will not apply to you. No restriction will be applicable. These are 4 points of non-applicability. Then they wrote 3 more points for exemption. 3 more points for exemption. There are 3 more companies that provision will not be applicable. First, government company. Government company which has obtained approval of concerned government, whether it's CG or SG, whichever approval. That I won't comply with section 185, it's fine. You won't have any problems. Secondly, if you are a private company, if it's private company that meets 3 conditions, it's important. There was a very good question on this. Private companies that meet 3 conditions. First condition, there is any body corporate shareholder. Does your company have any corporate shareholders? Does Dawood Ibrahim has shareholder? It will be BC. But it's individual. He can be shareholder, but your company cannot have body corporate as shareholder. Secondly, borrowing of your company should be less than certain limit. What is the limit? Limit is 2 times paid up share capital or 50 crore rupees. Your borrowing should be less. And third, there should not be any default in your borrowings. Section 185 will not apply to private company. Whereas the third point is that if you have Nidhi company, a Nidhi company, and Nidhi company gave loan to its director in the capacity of a member, Nidhi company gave loan. And this loan that you have given, have you disclosed it in your accounts? So the law says that there is no point. Then you applying 185 won't be of any use. There is no point. Then you applying 185 won't be of any use. I hope this point is clear. Moreover, exemption and these other 3 things, understood? Government company, private company, and Nidhi company. This is divided into 4 parts. Section 185. And if you need it, you can pause the recording and read it completely. Let me just see if any point is missed. Okay. Penalty for contravention if you have contravened 185s. 3 people are penalized: company, officer in default, and person who is given loan, guarantee, or security. Company and officer in default, person who is given loan, guarantee, or security. Company will be fined, all 3 will be fined 5 to 25 lakhs. It's same for all 3, 5 to 25 lakhs. But for the officer in default, that can be up to 6 months jail. Up to 6 months jail is possible. Then the concepts have very good points. Few things are important for exam point of view. We discussed that in class, you all should read it on your own. Please read it. Come to the next section, which is section 186. This is important. Please don't ask me for these notes. They are rough notes. I don't have it. I am making you write this in rough to create concept. Don't worry guys, class students will get these scribbled notes as they are. Okay. Now listen to me. What does section 186 states? It's good topic. Listen carefully. Section 186 says that if your company wants to do loan, guarantee, security, or investment, you will have to comply with this section. Subtraction 1 is on different part. It says that no company can engage in more than 2 layers of investment companies. Cannot engage in over 2 layers of investment companies. What does investment company mean? Company, its principal. Furthermore, principal business is the acquisition of securities. I hope this is clear. And there are 2 types of investment company. 2 type of investment company. Investment companies can be formed in 2 ways. You will be considered an investment company if your total assets exceed 50% or more. If it's over 50%. If your total assets exceed 50% or more, that is coming from these investment companies. And the second one is investments. If your total assets exceed 50% or more, that is coming from these investment companies. If your total income is 50% or more, is coming from these investment companies. You will be termed investment company. But listen, you are given an exception in 2 cases. If a company acquires an abroad company, and they have acquired it and the abroad company. If you invested in company for multiple years in investment company, according to law there, it's fine. I explained to you an example when Tata Motors acquired Tesla, right? If you are acquiring a broad-based company, it has multiple layers, then fine. Second point is that if any of your subsidiary company want 2 or more layers, then for compliance with any laws. So I said, I need to put my mind to it. One thing to keep in mind is that an investment company will be considered investment company if total assets are at 50% or more. The investment assets are from the total income of 50% or more of those assets. Okay. Only then you will be considered an investment company. Next. I said that your loan, guarantee, and investment are done. After that, I said now the real provisions will begin. The provision is that if a company wants to provide loan, guarantee, or security, it wants to provide. To whom? To any person or any corporate body. Any person other than employee, any person other than the employee. Or if you want to make an investment by way of acquisition or subscription. Whom? To any corporate body, any securities. Law says you have to do it. It's fine, but there is limit. The limit is 100% of free reserve plus security premium, or 60%. paid up share capital plus free reserve plus security premium. Whichever of these two are higher, that will be your limit. If you are going above this limit and making a loan, guarantee, security or investment, then we told him that he would have to comply with it. First, a board resolution has to be passed. Whether it's within limit or outside, you have to pass board resolution. And the resolution must have the consent of all directors who are present. All the directors who are present in the meeting, they cannot refuse to vote or vote against it. They will have to vote in their favor. Can I pass the board resolution through RBC? No, board resolution can only be passed at board meeting. It can't be by circulation. Resolution by circulation is not allowed. After that, you will have to pass the SR, pass SR. Will you pass the special resolution if you are going over the limit, say? Even if you're going above limit, you will still have to get SR pass. But there are exceptions to that. What is the exception? If you are giving loan, guarantee or security to your own subsidiary or joint venture, or if you are investing in your holding company subsidiary, you don't have to get an SR pass. When will we have to pass the SR? We have to pass SR when we are above the limit, okay? But if you are going above limit, what is limit? This is limit. If you are going above limit, but still giving loan to a subsidiary or a joint venture, or investing in wholly subsidiary, then you do not have to pass the SR. Listen to my third point. Third point is that you have to get approval from PFI. Always get the approval. Getting approval for the PFI also has an exception. If your loan, guarantee, security or investment is within limit, and if you haven't defaulted on any loans, then you don't need to get approval for the PFI. But otherwise, if you have a term loan pending from a PFI, then you will need to get their approval. Loan agreement was made for PFI from whom money was taken. The loan agreement does not mention that you need approval. So do you need to get approval? Yes or no? Tell me. The law says you need to get approval, so you will have to get approval. After that, you will have to give a disclosure. In disclosure, you will inform everything. Tell full particulars. And you will also tell them what the recipient intends to use the money for, what purpose. You have to tell them this. After that, keep in mind. And remember guys, that whenever you are giving loan, interest rate should be higher than the government yield. It should be higher than government yield, not less than. And there is also an exception for this. If it is a Section 8 company, it should be 26% or more. So far you have only seen Section 8 companies. Do the government company creates trouble for you? If Section 8 company whose 26% or more of paid up share capital is held by central or state government, and if this company is giving a loan, right? It can even give loan at lower interest rate. And why is it giving loan? To fund industrial research and development. Objective is to fund industrial research and development. It's written in its object clause. I hope this is clear. Hence you guys can give loan. Who reviews it in such detail? I explain everything in detail. Okay guys, I will not leave it. Why to leave it when everything is read? Now listen, there are few points. Let me complete it. Quickly do it. Okay? But is there any other point left? Is it necessary to give the meeting agenda? Is it necessary to give agenda? And how important this meeting is, where everyone has to come and vote. Is it necessary to give agenda? Law says no. It is not necessary to give the agenda. After that, you can read this point by yourselves. Please read this by self. As long as your default subsists, you cannot make any loan, guarantee, security, investment. If we took deposit from public and that deposit's repayment has not happened, so you cannot make LGSI. After that, sir, you will have to maintain a register. Which form will you maintain the register in? You will maintain a register in the form MBP2. Maintain the register in form MBP2. You have to provide particulars, details of all loans, guarantees, securities, investments. All entries will be chronologically. You understand it? Chronologically, all entries will be within 7 days. Moreover, after that, who will authenticate it? The company's secretary or any person authorized by you. Okay? After authentication, who will be in custody of it? Will it be back with the CS or in their custody? Tell me. For how many years will you reserve this document? Law says permanently. For entire life, as long as this document needs to be preserved. This is all written here. These things are written, these things that will be remembered. After that, last, your non-applicability and exemption. They are talking about non-applicability in terms of loan, guarantee, security and investment. It won't apply to 3 companies: banking company, an insurance company, and housing finance company. Furthermore, if you are talking about investment, this provision will not apply to these 3 companies. Okay. It won't apply to investment company. While second, this provision will not apply when you subscribe to write shares. Okay. Third, if it is a non-banking financial company whose principal business is investment, so that will not be applied. That will not be applied. This becomes non-applicability. Now, after that, if I come to exemptions, then they have exempted 2 government companies. One government company is involved in defense production, and the second is a government company which has already received approval from the CG or SG ministry. That provision will not be applicable to both of them. If any government company that has received approval from CG, SG, and if you do contravention, you will be fined. 25,000 to 5 lakhs, 25,000 to 1 lakh for OID. And this fine or penalty, you can have imprisoned for 2 years of jail. Under 185, it was 6 months in jail. Here it's 2 years in jail. Now, I'm not going to tell you about 179 versus 186 right now. And you people have read in class that it's written in 179 that you can delegate. But power for investment loan guarantee security, you cannot delegate because you will need unanimous consent in the board meeting. Consent from all directors present in the meeting is required. Now, let's read section 188 first. Let's read 188 before 187. I will explain section 188. Guys, please, I need motivation. You guys have to like this video. I need motivation, okay? Guys, those of you who are watching online, please like this video, friends. Like the video. If you need this type of revision, we need at least 200 likes on the video. You guys must like this video. There's a new latest revision coming for you. Tell me where in the market is it coming in. Friends, if you guys want more revision videos like this, you have to like this video. And you all please take a moment to comment and tell me how you like the revision. Because trust me, your appreciation is my genuine motivation. So make sure to like the video and comment. Okay? Understand? Let's go. Okay, let's move on. What is 188? Listen carefully to what I'm saying. Related party transactions. About what, friends? Related party transactions. What is related party transaction? Related party transaction is if a company is doing transaction with its related party which we have specified. So did you understand what I'm saying? To understand related parties, you must understand relatives. Okay, so relative means like my spouse, father, mother, brother, sister, son, daughter, husband, daughter's wife. No, this is not valid. Son's wife, daughter's husband, these are your relatives. And also stepfather, stepmother, stepbrother, stepsister, and stepson, these become your relatives. After that, in a Hindu undivided family, all members are related to each other. So if I talk about related parties, then who falls under the definition? In related party, listen carefully to the definition. If this is a company, then this person is a related party to them. Who? The company's director, key managerial person, or their relative. So if I talk about the firm, then that firm where company's director, manager, or their relative is partner, that firm is your relative. Or if I talk about a private company, so that private company where your company's director, manager, or relative himself is a director or is a member, listen carefully. So that private company would be considered related party. Or if I talk about a public company, then that public company in which your company's director or manager is a director, and along with that, the director along with the relative holds more than 2% of the shareholding. So both these conditions should be met. Then public company will be considered related. If I talk about body corporate, so a body corporate can be related in 3 ways. Firstly, if I talk about if you are a normal company, holding company, a subsidiary, an associate, or any subsidiary. Co-subsidiary means any holding company's remaining subsidiary are called co-subsidiary. Secondly, if there is any investment company, whoever invested in your company and invested so much that you became an associate, right? Then that investment company will be considered related party, otherwise no. It's investment company who invested less than 20%. So it would not be considered related party. And lastly, that company at whose behest your board of director is accustomed to act. Accustomed to act. Okay, so that will also be considered a related party. After that, we said any other person, okay? Any other person on whose advice, direction, or instruction board of director is accustomed to act will also be considered related party. And such other person as may be prescribed. So what did they prescribe? The director of holding company of that company, the managerial person. And what will we consider relative? And what will we consider relative? The related party. And this director you mentioned, don't include independent directors in that. Means the independent director of my holding company will not be considered my related party. The related party of my holding company. So, the independent director of my holding company will not be considered my related party. This is your related party. After that, you should also understand certain transactions that happen with them. We call it related party transactions, like supply or purchase of goods. After that, services, the availing or rendering of the services, properties buy or sell, or property lease. Or when you route all these transactions through an agent, they're considered related party transactions. Or appointing any related party to office or place of profit is also considered related party transaction. Or if you are appointing them underwriters, it's still considered related party transaction. Now from here, if related party transactions are above certain limit, then what will you have to pass? You have to get the approval of shareholders. What is the limit? Turnover is 10% in the case of goods. Turnover is 10% in case of services. In property buying and selling, net worth is 10%. In your leasing case, it is 10% of turnover. And through agents, it's same limit, the respective limit. In office or place of profit, if remuneration is more than 2.5 lakhs. And if in the case of underwriting, it is more than 1% of net worth. So what would we call all of these things? We would call them things that go above the limit. Everywhere it is more than equal to, but only in the remuneration it is more than, and in net worth it is more than 1%. The last one. Everywhere it is more than equal to, except for remuneration it is more than 2.5 lakhs, not equal to. And in underwriting it is more than 1%, not equal to. That's the limit now if you're having a related party transaction. And it's going over the limit, then you need to get approval of shareholders. Approval of shareholders. But otherwise the board's approval is necessary. How will you get shareholders approval? Raw said to take it by passing the OR. First, let's talk about board's approval. The board's approval will look like majority approval. But for the board's approval, it is necessary to send the agenda this time. You will mention many things on agenda, like who is related party and what transaction is happening with them. What's the nature of transaction and what's the duration and term. You will have to tell the board all of these things on their agenda so that they can come and pass resolution. So will interested director vote in the board meeting? No, absolutely not. We know that interested directors will not vote. Board's approval would still be required whether it's within the limit or not. If it is 188 RPT, then you will need the board's approval. And after that, second, will OR apply or will SR apply? An ordinary resolution will apply. Although related party transactions are a big deal. But even then, what will we consider applying? We'll consider applying OR, not SR. To pass an ordinary resolution, you'll need to send out a meeting notice again. You will attach a lot of things in the explanatory statement. You'll attach like who is the related party, what is the transaction. You will mention all these things. But the OR that you need to pass, you don't even need to pass the OR in 3 cases. In which 3 cases do you not need to pass OR? If transaction is happening of holding company or wholly owned subsidiary, or if there is a transaction between a government company and another government company, or if there is a government company which has obtained approval from CG or SG, will also not need to pass an OR. I will just tell you one thing to remember. If there's a transaction between holding company and wholly owned subsidiary, so you don't need to pass an OR. You do not need to pass an OR. Did you understand what I'm saying? Did you understand or not? After that, there is a very important concept. Listen carefully. When you called the meeting to pass the ordinary resolution, so then in the meeting, every available members of related party of that transaction, that member will also not vote. But those members will also vote, I mean in a way, interested members will not vote. But they will also vote if the total number of members, if 90% of the total number of members or more than that is the promoter's relative, are either the promoter's relatives, or they are the promoter's relatives, or they are related parties themselves, 90% or more than that. So the law said if the members are more than 90% in number and are interested, then what will we gain by stopping them from voting? You cannot stop them now, this entire provision, right? That the 90, that related party will not vote. And if related party is more than 90%, then they will vote. This also has 3 exceptions. What are those exceptions? First, private company. Second, government company that is transacting with the government company. And unlisted government company. Provision will not apply to these 3. If you think it's difficult, then cut it. But at least remember the above 2 points. That member who is related party will not vote. But if more than 90% of the members, 90% in number, are promoters relative or are a related party, so then all of those people will vote together. Now sometimes what happens is, if a company did a related party transaction and it required the board's or shareholders' approval, you didn't take it and entered into transaction. So you can get it ratified within 3 months. Either the board or shareholder will ratify it. Second, okay, and if you did not get it ratified, then it will become voidable. Who can void it? The one whose approval was taken can void it. And third, you can also tell the director to indemnify it. Indemnify means, if the company has incurred any loss, you can get that loss compensated. And you can also initiate proceedings against director for recovery of losses. You can also file a case on the director to recover the loss of money that has happened. And also listen, if you are doing any related party transaction, then you will have to make full disclosures. And along with that, you will also need to justify why we're doing transactions with related party. But listen, the related party transactions, this entire section 188 will not be applicable if. Now, do you know what it states? It states that this section 188 will not be applicable if you are engaging in a transaction in the ordinary course of business at an arm's length price. If you are engaging in a transaction in ordinary course of business, the entire 188 is not applicable. This is what they have written. And at last, there's contravention. What's written about contravention? If you have contravened, then in the case of a listed company, it was 25 lakhs. And in case of unlisted company, a 5 lakhs penalty is imposed. 25 and 5 lakhs penalty is imposed. So friends, will you be able to remember all of this? I have explained the entire provision for related parties to you. I hope you understand it. Just go to the chat section and comment, okay? Just comment yes if you have understood. Please let me know. Just tell me, were you able to understand? So yes or no? Speak up. Are all of you guys with me? Did you understand? I said after 188, 187 is left. 189, 190, 191, 192, 193. Look, we won't go over 191 now. We will revise it with 202 and neither 193 because it's 1% company and you can read it yourself. Now we will do 187, 189, 190 and 192. Listen to what 187 is. What is section 187? Listen carefully. 187 says that the investment will be held by the company in its own name and not in anyone else's name. Do you know that a company is a separate legal entity and it can very well hold property and things in its own name? It will not hold property in the name of its directors or members. Okay, so listen, the investment that we are talking about here is not just security investment. Assets are included in this. When you mentioned investment in 186, it was of security. In 187 investment, asset, property or anything is included. All investment made or held in property, securities or assets will be held in its own name, but sometimes what happens is if you are making some company or wholly owned subsidiary, so there should be minimum 7 members in public company. So to meet the number of members, you give one share each to some people and make them nominees. So then the shares wouldn't be in your name, they would be in nominee's name, and that's allowed. There are 4 exceptions to mentioned provision that you will hold it in your own name and not in others. First exception, if you are holding it in the name of a banker for dividend collection, or also if you are holding it in the name of a banker for transferring the shares, then that too can be held. But if the transfer did not happen, then name will be back within 6 months. So it should be given on the company's name. And thirdly, if you have given it as a security for repayment of loan or performance of obligation, you said that it was given as a security to some banker or any other person. Law says that it happens. And fourth, if you are holding investment in the name of depository, in case where company is beneficial owner, means if you are beneficial owner and if you are holding in the name of depository, law says that it's okay because it happens in demat. So if you have given it to someone for dividend or given it for transfer, or if you gave it for the security, or if you hold it in name of depository, so the law says it is okay. And whenever a company holds shares or does investment, not in its own name, but in someone else's name, they will have to maintain a register. They will maintain that register in the form MBP3. You will include all the details in it and it will be open for inspection. Here you will enter all the entries chronologically. And you will also have to tell who the person holding it is and what our relationship is with them. And the reason of why we are not holding it and they are. All entries will be authenticated by the CS who is authorized and keep it in their records. And this will be permanently preserved. This is penalty for contravention of section 50,000 to OID and then 5 lakhs to the company. This is a very basic section and there's no need to memorize anything. But it doesn't mean that it will not come in the exam. Hold investment in your name. Remember the 5 exceptions. First, if you appoint nominee for minimum number of members, which is mentioned above, then there are 4 exceptions for dividends to transfer. And if you have given it as a security, or also if you have given it to the depository, if it's taken in depository's name, then it's okay. After that, come to section 189. What does section 189 says? You will have to maintain a register. These are very basic points. Listen to them. A register will have to be maintained, where you will tell all the contracts and arrangements of 184.2 and 188. What does 184.2 means? Specific interest 1. And 188 meaning related party transaction. You will have to maintain this register in the MBP 4. What was MBP 1? General disclosure. What was MBP 2? I don't remember. What was it? Please you all tell me what was MBP 2 because I can't seem to remember it. I don't want to check, so tell me. I'll tell you what MBP 2 was when I remember it. MBP 3 which you studied in 187 and MBP 4 which you are currently studying in 189. What will you include in this MBP 4? Include the particulars of contract or arrangement entered into with the body corporate under section 184 and 188, besides whatever contracts or arrangements have been made. Company's body corporate or association in which director has interest or concern. Meaning you will only have to tell the name of the company which the director has disclosed in the section 184 subsection 1. Okay, did you understand? It will be chronologically entered, authenticated by CS, kept in custody and permanently preserved, and if anyone requests it, then you must make it available within 7 days after taking the fees. If someone requests this document. But there are two more important things to keep in mind. The transaction of 18242 and 188 transaction. 184.2 transaction comes and 188 transaction comes. Okay, listen. Any director or key managerial person will disclose their interest of 184 to the company within 30 days. I mentioned this same point in 184. You will have to disclose it within 30 days in MBP1. This register of yours, you will keep it in the registered office. And it will be open for inspection during the business hours, right? You will also take this to every AGM. Above is written that you will keep it in registered office, but below is written that you will take it to AGM. And it will remain accessible to the person who has the right to attend such meetings. Meaning it will be available for inspection for every member. Don't include two kinds of contracts and arrangements in this. First, if any sale, purchase, supply of goods, material occurred and amount is less than 5 lakhs of all year added together, so don't include that. And second, if banking company is collecting bills in ordinary course of business, so don't include these two. If amount is less than 5 lakhs in year, and second, if banking company is collecting bills in ordinary course of business, the director will face penalty of up to 25,000. Please read this provision in section 8 and our last section for the day. Second last actually, we also have 192. What is the last section? What does it say? Your managing director and whole-time director, we are talking about two big directors, MD and WTD. If you are entering into any contract or arrangement with these two directors, or if you're making any agreement, that contract should be in writing with its copy. But if it's not in writing, then you should make a written memorandum in which you will write all the key terms. So now this contract of yours, right? You will have to keep this in the registered office. And also you will keep this open for inspection without any fees. If I wanted to go today and see the agreement between Reliance and its MD, so I can see it without any fees because it will be kept in the registered office. But if it is not kept there, then the company will have to pay 25,000. And the officer in default will have to be paid 5,000 means. If you have any contract with MD or WTD, then it should be in writing along with a copy. And if it's not in writing, then make a written memorandum for it. And you will write it in the memorandum. So did you understand what I'm saying? We will read 191 along with the next chapter with section 202, but now it's last section for the day. If you guys like the revision, then friends, please be sure to share this with your friends and may this video get a lot of reach. So that should be my motivation and that should be the appreciation I receive from you guys. Please listen, it's last section for today. Section 192 talks about restrictions on non-cash transactions involving directors. If there's any such transaction happening where company is receiving something other than cash or something is going other than cash, meaning assets are coming in or going out. So entering into that kind of arrangement where no company shall enter into an arrangement by which director of cash or person associated with him acquires assets from company for consideration other than cash. The director of cash is getting an asset from the company or company acquires asset from such person for consideration other than cash. Whether company is getting asset or director of cash is receiving it and consideration is other than cash, so you will have to get prior approval in general meeting. Prior approval has to be taken in general meeting. I explained the logic to you why prior approval has to be taken and why are we holding this. But please listen to me very carefully. If the director is of the holding company, then the resolution, it will also pass in general meeting of holding company. So meaning if I'm doing it with the directors of my associate company, so I'll pass approval in general meeting of my company. But if I'm doing a transaction with directors of my holding company, so what will happen with holding company? Approval will happen. I explained the logic in class of why it wouldn't happen with subsidiary company. Now listen to what I'm saying. You will have to send the notice in general meeting in which you have to provide all the details like what the particulars are, what the values are, and you'll have to tell everything. But listen to me, if you didn't take the shareholder approval and did a non-cash transaction without passing OR in general meeting, so this will be a voidable transaction. The shareholders will make this transaction voidable unless this will not be voidable in two cases. First case where restitution is not possible. Restitution isn't possible means the subject matter that was or asset has now been destroyed and its restitution is not possible, reversal is not possible. So it will not be voidable. What did I say? Where the restitution of any money or the other consideration which is the subject matter of the arrangement is no longer possible and the company has been indemnified by the person for any loss or damage. I told you the asset that I transferred has now been demolished. The property has been demolished, so now how will you make restitution? Just keep in mind that indemnification shall happen, meaning the company's loss will be indemnified by the concerned person. Or second, any rights acquired, bona fide, for value and without notice of contravention of provision by any other person, meaning we gave the asset to director and the director sold that asset to a third person. So the third person acquired it in good faith. And then what did they get? They got the rights to that asset. And that too without the notice of contravention. So now that they got the rights, you cannot take it back from them. This was section 192 and you can read the section 193 about 1% company. It's very easy. And I will revise 192 for you in the next chapter. If you guys want the next revision to come out quickly, then like the video. Be sure to let me know in the comments and I will see you in the next revision. Until then guys, take care. Have a very productive day. Bye. Good night. See you. Bye.